Right from the start, the tension is thick. A custody dispute, missing school weeks, and both sides gearing up for a legal showdown. Watch closely, this one's about to get complicated.
My client has a number of safety concerns with regard to Ms. Woodfork and her home. He basically told my client to contact your lawyer or have your lawyer contact my lawyer, and she wasn't returning the kids to my client.
You're saying that your client has no problem turning the children back over?
Oh, I'm saying we absolutely have a problem, but
I'm not going down that pipe today, sir.
The children have not been in school, I don't believe, for the last 2 weeks.
Everybody knows where everybody lives.
I don't want to share that information with you.
Yes, Your Honor. I would like a final order today, but I don't think we're going to get to that point. So if I cannot have a final order...
There's a motion for enforcement also I didn't go into, but it hasn't been, there's been no citation or no service at this time that I can see that was filed earlier this month or last week. So obviously there's some things out here that still might be pending even after today. So you may proceed with that opening again, ma'am. Sorry about that.
If I can't get a final order, I'll take a temporary order setting the child support and medical support after a hearing. However, I'm not sure who should be paying the support. I do have some calculations for both parties depending on who gets ordered to pay the support. And I believe that there will be zero medical support because I believe Ms. Woodfork can put the children on her insurance at zero cost.
Notice that the attorney's distancing themselves from the custody question. That's strategic. They're focusing on child support and safety first, letting the court determine who gets actual custody later. Smart move when facts are still disputed.
And then I would like appropriate findings on family violence, non-disclosure, and court costs. And I have no position on conservatorship, possession, and access, Your Honor.
All right. Thank you very much. I'm going to go ahead and start with you, Ms. Henson, since you're the counter petitioner in this matter. Well, you're the, according to the state, you're representing a non-custodial party, but that could be wrong. But this time I'll start with you, Ms. Henson, and then go to Mr. Gunn for an opening for his client. Thank you.
Yes, Your Honor. So we are asking for a temporary order today and that the case be referred to district court. At the time prior to today, when the parties separated in October of 2024. They were living together with the children up until that point. The children, after Ms. Woodfork vacated their shared home, in October of 2024, the children remained with my client and were with my client up until the last week of August of this year. So the children were living exclusively with my client. So today we are asking that the court reinstate the status quo, which had my client as primary conservator in this case, and then that the court make appropriate orders for possession and access with regard to the children. My client has a number of safety concerns with regard to Ms. Woodfork and her home, the children and the activities going on in the home. So at this time, I do not know if it would be appropriate for Ms. Woodfork's visitation with the children to be supervised or if there just needs to be daytime visits. But we do believe that it's not in the children's best interest to continue to reside primarily with Ms. Woodfork. So that would be what our requests are today.
All right, and it's your allegations that, again, I hadn't had a chance to go over this, but it's your allegations that the father had the child, the children, and that the mother refused to return them, or that there's some violation of the standing order in this matter for that purpose?
That is correct, Your Honor. It's my understanding that there was an initial communication by Ms. Woodfork that she would return the children back to school the following Monday morning. This was, like I said, the last week of August. But then she didn't do so. There were a couple of conversations between the parties thereafter, and she basically told my client to contact your lawyer or have your lawyer contact my lawyer, and she wasn't returning the kids to my client.
Okay. All right. Mr. Gunn.
Well, let's see. Good morning, Your Honor. The court is correct. There are motions pending in district court this time.
And here comes the bombshell. The alleged father hasn't even been legally recognized yet. That means, technically, he has no rights until the court officially confirms paternity. This one legal detail changes everything about custody, support, and access.
Both attorneys have filed motions objecting to an associate judge hearing a final. If we're going to operate under the local rules, there has not been a mediation attempted prior to final, but perhaps most importantly, as of right this moment, the individual, the other party, is not an adjudicated father of either one of these children. In fact, DNA was just filed, I believe, on Monday. I believe there was a request for DNA testing at some point earlier this spring. I had asked about this as recently as about 2 weeks ago, and it hadn't come back. Apparently, it's just now come back. I still haven't seen the results. So, if we're going to get into a temporary hearing today of some sort, that's fine. But there has been no, up until now, and right as we're speaking now, still is not an order adjudicating this individual as a father of either one of these children. So there's that issue. If we're going to go into other issues, we can touch upon the fact that the father has a rather lengthy criminal record, including convictions for family violence and some other crimes, including up to the felony level. So we have some concerns about him having possession and access at this time. I do need to further advise the court that in the process of attempting discovery, and I say that respondent has responded to discovery. It looks like both of us are listing multiple witnesses, lots of evidence, 20, 30 plus exhibits. So if we were going to get into a hearing on the merits, I would respectfully ask that that be, if we're not going to remove it, that be set on a special setting in person to allow both parties to present their evidence. The physics of the reality are that I anticipate 2 hours easily, and we've got exhibits, we've got other matters that need to be addressed, just the physics of entering exhibits and so forth that they're going to come forward. So there's a whole lot of things going on here. I do need to advise the court that I'm unavailable after this afternoon. So this was, for some reason, was put on a general docket, which is fine, but that's kind of our position at the moment. Again, is that there has been no adjudication of parentage. To our understanding, I've been tracking this thing for a while, looking for it. I thought you had made an order at some point, Your Honor. I don't believe you did.
Well, the original petition does request a determination of parentage. Did not.
There it is, 99.9%. The moment of truth. The DNA test removes all doubt, officially making him the father. But while that's a win on paper, it also opens the door to deeper questions. Will his past criminal record influence what comes next?
And then those all the crosses. Everybody filed the standing order with all their crosses. The state filed theirs with theirs. And where the heck is that? Okay, the order of paternity testing. Let's see, that was done back in June of this year.
Your Honor, if I may, there are DNA test results that show that he is the father.
Okay, well, I kind of figured that, but still. All right.
That would be news to me. I still haven't seen them, and they were just filed with the district court on Monday. So, be that as it may, I realize that needs to be addressed, but.
All right, and you're saying that, okay.
And if I may address the court further when you're ready for just a moment on a housekeeping matter.
And it's your testimony, or I'm sorry, your opening that both of y'all have also filed district court.
That is correct, Your Honor.
Yes, Your Honor, and I don't mean. I'm sorry, ma'am, I didn't mean to cut you off.
No, that's all I was saying. You're good.
I was going to say, if I may.
Both of them were after the state filed theirs in 4D, correct?
Yes, Your Honor, I checked. I don't mean to speak for the young lady, but it looks like hers was filed on February 3rd with item 2 as an objection. We filed ours originally on May 15th with an objection, and then another on June 25th.
All right, same district court or different district courts?
Negative, they're all the same, and it's all in the same cause number, all coming out of the 169.
169.
Okay. All right, what's the other matter, the housekeeping matter, Mr. Gunn?
Negative, that was it, Your Honor. I believe the young lady beat me to it. That I figured you would want to know when was the objection filed. It was filed for all intents and purposes immediately. I believe the state filed their motion, I want to say, in December.
All right, this originally was filed in December, correct?
And Your Honor, if I may follow up, if the court does not have the time and ability to have a thorough contested temporary orders hearing today, which I completely understand and respect, we'd still just ask that the court order the parties to go back to what the status quo was, where the children were in school in Bell County, as opposed to where the children are currently with Ms. Woodfork. I believe she's in Williamson County in Round Rock.
Judge, I have no problem with the school, with the school staying with the kids, but you know what I mean. We have no problem with that, and I've instructed my client to the same.
All right, then. So let's see. The first counter came in February. And before then, both parties had filed a request for hearing and made technically general appearances without an objection, folks. And you're aware of that, correct?
I'm aware, Your Honor.
Okay.
I was not.
Okay.
And Your Honor, we are fine if the case needs to stay in 4D court, but as counsel indicated, we would just need a special setting and more court's time if ultimately we're going to remain in 4D court. I think our primary focus today, at least mine and my clients, is having the children return to where they were. And then if the court needs to set this down the line at a special setting, then be as it may. That's okay too.
Judge, there's no motion on file for that. At least, I'm sorry, let me correct. There's no filing set on that for today. It is only set for final. That's part of the concern. I do agree with my opponent. This would need a special if you retained it.
Oh yeah, well, I plan on retaining it because again, I've had the conversations with my DJs and believe this is going up quite frequently lately. And yeah, if it's my case, I got to set it up. I need to take care of it, and I don't mind doing live settings. I just got to find a date for it to be appropriate. And obviously, both the standing order does control here also. And Mr. Guy, you're saying obviously, I'm sorry, you're saying that your client has no problem turning the children back over?
Oh, I'm saying we absolutely have a problem, but I was addressing the second part of that statement, which was that if the kids need to remain in their present school, that's fine. It's not ideal for anybody, I suppose, but that's fine.
Okay. Well,
again, he's as of 11:32 Central right now. He's still not adjudicated. There's no order saying he's the father.
We can do that right
now. That's about to happen, but there is no order.
well, I'm getting ready to do it, Mr. Guy. And again, anybody goes against the, they're before the court. They know, technicalities are not going to fly with, will not fly 100% with violating the standing order. And if that's the case, then I will go ahead and have a hearing on that today. But as far as where I think the children need to go back to, but again, if I get the information that they were with dad and mom refused to return, I'm going to, even though both parties are properly before the court, both parties had received copies of that standing order, and it had nothing to do whether or not dad is being adjudicated the father. So that's going to be problematic. So we'll take care. Well, if we need to, we'll take care of that.
With all due respect, that is the entire issue. If he's not adjudicated as the father, he has no legal claim to the children.
Mr. Gunn, okay, and even if he wasn't, probably had standing to file custody anyway.
But they didn't plead for that.
I'm not going down that pipe today, sir.
Judge, I am. They didn't plead for that. If the court is wishing to proceed, I understand that. But I think that bears importance. That's the whole reason the state filed this.
Well, I'm getting ready to go ahead and enter and have the state. This is at the final. I'm going to have the state introduce the DNA paternity analysis. And we get ready to nip that part in the bud, and then we'll take care of everything else we need to. And we'll start looking at some dates, whether or not we need to set this up for a further temporary order with a live hearing, and whether or not what we're looking at as far as the final is concerned. But at this time, I'm going to go ahead and let the state present present her evidence as far as paternity, and we'll take everything else up after that. So at this time, Ms. Bachelor, you're up now.
Your Honor, may I share screen?
Yes, you may.
Okay, so we have the child Jax Lee, and then the 99.9%. And then if we scroll down, we have the child Venetia Lee, and that is also 99, actually 0.8, Your Honor. And I believe that this is on file already.
All right, well, I'm going to have you mark those as State's Exhibit number 1. And I'm going to start with you, Mr. Guy, go with you. The state, this is court order. These are the results for said for DNA paternity analysis for the 2 children. Is there any legal reason the court should not give these evidentiary consideration at this time, sir?
Negative, Your Honor.
All right, Ms. Henson?
I have no objection, Your Honor.
All right, stage one's admitted. Stage one shows that Mr. Walter Lee is the biological father of both children in conformity with the Texas Family Code of being at least 99.9%. So I will also find at this time. All right, then, guys. Yeah, he's dead. That's not a problem.
And the judge doesn't hold back. Violating a standing order, especially one about removing kids from school or the home, is a serious misstep. Judges take stability for the children seriously, and this could cost her major credibility moving forward.
Now, all right, well, right now, where are the kids going to school?
Not certain if mom has them enrolled in school or not, since she's had them.
They are enrolled in school, and she has been instructed to leave them where they are, which I believe, correct me if I'm wrong, I believe is the court, where they had been enrolled previously. I started to say ran off, but I think that's where she's living.
Mr. Lee, where did you have the children enrolled in school?
One block over from my home, Cedar Valley Elementary School. Venicia had been in the school for 3 years. Jack's been in the school for 2 years.
All right, so where are they at this time?
With Miss Woodford. Excuse me. Ms. Woodford, the court has a question for you.
Didn't copy the audio, Doctor.
I'm sorry, can you repeat that?
Where are the children in school?
The children are still at Cedar Valley Elementary School. I never withdrew them from school.
All right, then, folks. Again, I'm looking at 1.4 under the standing order. Ma'am, you weren't allowed to remove them from their current the abode that was in place already previously. So you need to return. And I'm looking at I'm looking at doing this as a final order, and I will not hold anything against anyone as far as what happened up to this point. Obviously, I'm going to do what's in the case's best interest. If this was a little further out, I probably would point it at lighting, but we're going to go straight down without that lighting on this one and just go straight into final hearing.
Judge, may I address court?
Yes, sir.
Judge, again, do I understand this is over my objection? I do need to respectfully remind the court of two things. Number one, the motion is, I believe, it's filed, I don't know if it's been said, already in district court for what that may be worth today. Secondly, up until a moment ago, this individual was not adjudicated as the father of these children.
No. Again, I didn't see anything in the standing order saying anybody had to be adjudicated for anything, Mr. God. So the bottom line is the standing order was interfered with the abode, and mom did. So she
understood. Are my objections noted for the record?
Yes, they are. And not a problem, sir. So I'm sorry, the judge lost his point. I was looking at this other case that got set that next. Oh, I lost the next writing. The case from Heck is the next writing. Never mind. All right, then, folks. Let's go ahead. I'll go ahead and set y'all up for this. I will give y'all all day if necessary. And I tell you, I'm gonna go ahead and set up a Zoom code. I also want to go ahead and set up one for a free trial to make sure everybody's ready to rock and roll on that date. And what I'll do is set up a 10:15 like I did this morning on one date the week before, just to make sure everybody's got their ducks in a row, everybody's ready to go. I'll close this down for a second. Sorry.
Judge, do I assume that's your typical for attorneys only? Parties don't need to be present.
Oh yeah. Okay. I just want to make sure everybody's ready to rock and roll. And I'm looking at, since we're doing this on the October the 10th, yeah, there goes family. Okay, no, I'm not doing family code. I mean the advanced family, that's next month. All right, so gee, well, this was the week of. Okay, I'll do it the week before. I got the week of is booked up really good too. So, all right, folks, let's go ahead and do a pre-trial on at 10:15 on Wednesday the 1st. Like I said, only lawyers have to show up. Let me know everything's ready to go. And of course, someone from your office can do it if necessary. Officers can do it. And it's the Zoom code you'll get for the 15th will be the same one that will be for the first will be the same one for the final on that following Friday. So at this point in time, is there anything else or any other questions or information that y'all need from me at this point? Thank you.
Negative at this time.
So 2 points of clarification. I heard earlier that we were doing in-person setting for the final. So are we doing Are we doing Zoom for final? Because you said it's going to be the same one for the 10th.
Okay, I always say that by Zoom code no matter what, ma'am. Okay, just because it's my recorder now, so there's always a Zoom code. But yeah, everybody, the Friday's going to be live, but thanks to Zoom having all these good, all this good recording and cloud capabilities, we record everything through the Zoom cloud. So, but yes, ma'am. But yeah, it's live on that date on the final, and on the pre-trial it is Zoom. And like I said, I anticipate it'll be over in 5 to 10 minutes. All right.
And then the other point is, Your Honor, with regard to the return of the children, is there any orders from the court with regard to how and when that's supposed to happen?
All right, what weekend is this? Let's see. Gotta go back into my calendar. This is this.
Because I don't believe
this is the second weekend of the month, so this is not the visitation weekend for the other party. So Dad needs to pick the kids up. Okay. I thought it was in September. I was in August. I'm sorry. All right. So this coming, all right, Dad needs to pick the kids up from school today. All right. This is not we're out of visitation time frame. So Dad needs to pick the kids up from school today, or have someone retrieve them from school today.
So, Judge, I'm sorry. So Ms. Woodfork indicated that she has not unenrolled the children from school. The children were enrolled in school in Bell County. Ms. Woodfork lives in Round Rock. The children have not been in school, I don't believe, for the last 2 weeks. But somebody may have to clarify that for me. So if that's the case,
I thought you said that she had not removed the children from their school at this time. But go ahead.
My client indicated she did not disenroll them. It's my understanding there was some sort of a family emergency in the last week or so, but I don't know that covers all the dates we're referring to. But be that as it may.
The children are not presently in school. She did not unenroll them, but they're not physically in school.
All right, here we go, guys. All right, ma'am, here's the deal. Everybody knows where everybody lives.
We are not certain about Ms. Woodfork's residence.
Man, what's in the
I don't want to share that information with you.
Here's the deal. I'm the judge. I'll tell you what you're willing to share one way or the other. Because again, I'm the person who's going to be looking at you custody. I don't need your information, man. I just need to know what city you live in.
I'm in Round Rock.
All right, then. All right, ma'am. You're not at work right now, are you?
No, sir.
All right. So, are you at the? Where are you located, sir?
I'm in my home. I'm in Khalid, Texas.
All right. Can you be in Round Rock at the Round Rock Police Department at 5 p.m. to exchange the children, sir?
I can.
All right, man. Here's the deal. I'm going to order an exchange of the children at 5 p.m. this afternoon at the Round Rock Police Department. I haven't had to use these guys for a while. I usually use the Williamson County Sheriff's Department. But we'll go ahead and
Judge, you might want to specify Round Rock.
I'm getting ready to
okay. Understood.
I'm getting ready to get the address. So I'm well familiar with the Williamson County Courthouse, but not with the Round Rock PD. There we go. All right. All right, well, they're on Main Street, so I know where that is. All right, folks, the Round Rock Police Department is at 2701 North Main Street, and that's MAYS, just like Willie Street, Round Rock 78655, and that's where the exchanges take place at 5 o'clock. Obviously, it's 5 o'clock, in Austin traffic, so everybody just remain there until the exchange takes place. All right, anything else, folks?
Your Honor, is this just a reset or is it a temporary order, Your Honor?
This is a reset with the court making that order about the exchange taking place today.
Okay, Your Honor, I got it.
I have nothing else, Your Honor.
All right, Mr. Don.
Your Honor, I'm good.
Sorry, Your Honor, one more thing. So,
Yes,
the October the 10th is live in person. Where at? At the courthouse? Or?
In my courtroom.
Okay.
All right. They put me down. They put me down here on second, so this is where we'll be.
Yes, Your Honor.
All righty. All right. So everybody did, and I'll go ahead and set up the pre-trial and obviously the Zoom will be moved over for the appropriate time on for the recording purposes. But since it's live, we will not be broadcasting on YouTube on that date because that's a live date. So everything is confined to the courtroom at that time. All right, thank y'all all very much, and we're off the record, and I'll see the lawyers in about, at the first of the month, and I'll see everybody, back here on the Friday of the setting, and, we'll go ahead and wrap this one up. Thank you.
Understood, Your Honor. Thank you.
Thank you.
You're free to go.
All right, we're off the record. Thank you.
Thank you, Counsel.
Era, this is the power move moment. The judge takes control. Ordering the handoff at a police station signals a lack of trust and a need for safety. It's clear this case has crossed from family conflict into high-stakes legal enforcement. Things just got real.